continuing to take testimony on H2 and its amendments, and ask Marshall Paul to join us at the table. Thank you very much for being here, Marshall, and thanks for sitting in and listening to everybody else as well. And
Absolutely.
That's your family book there?
What's that? Yes, this is my 1-year-old family law
No, I
book.
pointed to the blue one.
No,
It hasn't moved yet.
okay, I just told my office to get me a new one. I said that I've been seeing the blue ones around.
yeah, I think
So-
Michelle keeps on forgetting to take it.
No, she confirmed that's ours.
Oh, that one's ours.
Yeah.
Oh.
Stop looking at that.
But
She said she did last year, so you want.
I put in I told them I was insistent that I get a new family law book, and they rolled their eyes, but they kind of nodded, so I think I was a yes. So thank you, Marshall Paul from the Office of the Defender General, and Deputy Defender General and Chief Juvenile Defender. I gave you the really short version of our testimony. The really short version is we support sections 1 through 9 and 14, and we don't support the other sections. And I can go through that and give you the reasons why, but feel free to, if there's parts that you want me to just move through quick, I can move through quick. And if there's parts you want me to give a little more detail, I can give a little more detail.
Okay.
So we support section 1, which raises the minimum age to 12 from 10. I will just say that as a juvenile defense attorney, I have represented, I think I can count them on one hand, the number of 10-year-olds I've represented, and not a single one of them has been found competent by the court, just based on their developmental age. And so I agree, I'm not going to repeat the testimony that others have given about the appropriateness of charging 10-year-olds in the first place, but just from a practical standpoint, it ends up costing money that because in order to, for somebody to be found incompetent, we end up having a couple of competency evaluations to the tune of, $5,000 each, plus court time, plus everything else. And I've never had a 10-year-old be found competent. So we support that. And just as a practical matter, we think it will have very little effect. And in those cases where it does have an effect, it's just going to save everybody a lot of time and hassle, because most of those cases are not proceeding anyway, but they go through a process before they get to that point. And really, a lot of those cases, the way we end up resolving those, literally everyone I've ever been involved in, is the youth is, the 10-year-old is charged with a delinquency. We go through a competency process. We determine that the youth is incompetent, and then they file a CHINS A or a CHINS B saying essentially, when it's a 10-year-old that's committing these kinds of problems, it's really not an individual child problem. It's a family problem, and we're going to address it at the family level through the child welfare process, not through the juvenile justice process. So that's our support for section 1. We do support section 2. We understand that some people might wonder why we support that, because that does expose our clients to a longer period of supervision. And in general, what defense attorneys do is try to minimize their clients' exposure to supervision. This is a unique case because we think that Vermont has been behind a lot of other states. There's this sort of narrative that Vermont has, that we're an outlier and that we work with kids in the juvenile justice system who are older than kids they work with in other states. And that's actually a myth. What we have is we have a higher point of entry into the juvenile justice system than other states, but we actually only have a lower point of exit from the juvenile justice system than most other states. Most other states have age ranges that are more like this, 20 or 21 as the maximum age range that their juvenile justice system will supervise. So this puts us more in line with what other states are doing. We think that's a good thing. We think also that I've seen the cases where everybody wishes we had a little bit more time. Everybody agrees it's appropriately a juvenile case because, the decisions that a kid made to get themselves into that position were really childlike decisions, but that we want more of the time than we're given to essentially provide treatment and support for that youth. And this provides that. So we are supportive of section 2. We're supportive of section 3 through 3, 4, 5, 6, 7, 8, and 9, because those are all related to one thing, which is to repeal the law that's in effect now, which would raise the age to 19, to age 20 to include the 19-year-olds to go into effect in April. We agree that we're not ready for that. We wish we were. We think that it's still a good policy goal. We're not saying that it should be repealed or that we should have a different plan. Raising the age to 18, I think, has absolutely every bit of evidence we've seen so far shows that it's worked, that it's been effective, that it hasn't caused us problems. We really can't do a full evaluation for a couple more years because by our definition in Vermont, one of the things we'll want to be looking at is recidivism. You need 3 years of good data just to do a recidivism study. And even that just gets you the barest minimum of a recidivism study. Because what you look at when you look at recidivism is, has somebody committed a new offense within the 3 years after they've completed their supervision? And so really, our problems with doing a recidivism study now are that we're coming out of the pandemic, and the pandemic was whatever we think about what happened during the pandemic, it's just not reflective of normal practice. And so we don't want to be comparing pandemic era practice to non-pandemic era practice. So we really are not even in a position to do a recidivism study yet. And on top of that, I think there's other things other than recidivism is one marker of success, and it's an important one. It's one that we should definitely look at. There's other things to look at as well in terms of has raised the age been successful that I think would be incredibly valuable. We just haven't done them yet. One thing that they did in Ohio that I thought was great, because we're always looking for ways to figure out what's working and what's not without spending a ton of money, because like a recidivism study is extraordinarily expensive and time consuming to do. Ohio figured out a smart move that I thought was great because they could do it entirely based on public data, which is they said, we want to see from the point that youth are exiting the juvenile justice system, once they're no longer under supervision, sometime in the next 3 years, what percentage of them are filing a tax return? That's based on public data. They can just look that up. And it's not saying that this person is doing perfectly well or not, but filing a tax return is an indication that you've probably integrated yourself into society in a reasonable way. Those are the kinds of things I think that even without a lot of resources, we can do some studies that show us whether raise the age is working or not. So we are in support of the provision of this bill that all of those sections, I forgot what I just named, up through section 9 that are part of delaying raise the age. That's because while we think it's a good idea, we agree that honestly, the pandemic threw a monkey wrench into everything we're doing. And if you look at like what happened to residential placements and DCF staffing during the pandemic, it was atrocious. It was decimated. It really screwed up our ability to provide services to youth. And that's being built back up. I mean, every day I'm getting updates from some of our providers that provide, less secure, what I would call medium tier. We talked about sort of the higher tier placements. I hear from providers in that medium tier placements that they're adding staff, which means they can add beds. What happened was all of these programs have staffing requirements, X number of staff per bed. And when they were losing staff, they had to shut down beds. It's not that the beds weren't there. They just couldn't staff them. And so they couldn't accept those kids. Those beds are opening back up. We're seeing more and more capacity in the residential care system, which is great. That's really one of the choke points that we see. I do want to comment a bit. There's a lot of focus in DCF's testimony and also just in general conversation about the higher level system of care, the higher tier system of care. And I think that's really important. We have advocated since Woodside closed that we need to be opening something to replace Woodside, some higher tier system of care. We've been actually really pleased. DCF has had Red Clover program open for about 3 months now. Everybody will agree it's not an ideal building, but the program is great. It is being Sentinel, which is the company that's being contracted with DCF to run it, is doing a fantastic job. They have done a fantastic job of hiring staff, which is one of the critical things when you're running a program like that. I mean, staffing, you can make or break a program based on the quality of your staff. They're doing an excellent job. And so that's part of what's been stood up. So what I'm seeing is that we're actually, the things that we need to accomplish in order to bring in the 19-year-olds, we're seeing it happen. We're seeing these beds come back. We're seeing the secure beds fall into place. We're seeing, really rigorous planning around a permanent secure juvenile facility. I'm on a committee that works on that. They've got drawings and site plans already. It's, at this point, debate about essentially where, the small things, landscaping, which buildings should go in which areas. So we're seeing things heading in the direction of, that it'll be appropriate at some point to bring in the 19-year-olds. We still do agree with DCF that a delay is important right now. If 19-year-olds were to come into the system on April 1st, the system would not be prepared for it. So we support all of the sections that are related to imposing the 2-year delay on raising the age to include 19-year-olds. That gets us to sections 10, 11, and 12, which all have to do with the proposal to make it so that if somebody is a juvenile delinquent, commits to multiple probation violations, that they could be transferred to juvenile court.
I like to call these our unconstitutional sections.
Yes, and so I'll skip over them quickly by saying they're unconstitutional.
So in event, but thank you again for putting out the case.
Absolutely.
But I would love to get your input on whether there's another way to kind of get at what we're trying to get at.
So I think the answer is yes, but you don't need to do it because it's already there. Because the question is, okay, so you can't transfer a case from juvenile court to criminal court post adjudication. You can do it pre-adjudication, and our current statute, section 335204, provides for transfer to the criminal division at any point up to the merits adjudication, which is actually the phase. I would disagree with Eric a little bit, and this is a tiny, tiny point of disagreement as far as when jeopardy attaches. He's right that there's language in Vermont case law that says jeopardy attaches at the point of adjudication, but what every other state has found and what's consistent with US Supreme Court case law is that jeopardy attaches at the point where the trial commences, that it's about being tried, not being convicted. So I know that in the criminal court system, jeopardy attaches when the jury is sworn. So when the jury said, when the oath is delivered to the jurors and the jurors swear their oath, that's when jeopardy attaches. Since there's no jury in a juvenile case, from our office's perspective, jeopardy attaches at the commencement of the adjudicatory trial. So as soon as you start calling
Not
witnesses.
necessarily the conclusion, it's when it commences.
Right, because in the adult court, it's at the commencement. And there's some US Supreme Court case law. In fact, it's the very same case law that said that juvenile cases trigger double jeopardy clause. One of the things they point out in there is they say that it is it's not conviction that triggers jeopardy. It's not punishment. It's trial and prosecution. It's trial that is the point of where jeopardy attaches. So what we think is that you already have provisions to do that. We have provisions to transfer cases from the juvenile division to the criminal division. And that gets to then this provision for an expedited process. And the expedited process in here, and this is now we're talking about section 13. This addresses a problem we want to address, but it doesn't do it. We agree with TCF this is the wrong way to do it. I disagree with TCF that the right way to do it is to go back to the old system. The old system was kind of crazy. It wasn't so much that it was unconstitutional, it just wasn't fair. It punished you for being innocent and rewarded you for being guilty. So because you had to enter a guilty plea in the criminal division in order to get the benefit of the juvenile system. So let me give you an example. If you have two kids who take a car joyriding. Let's say it's not grand theft auto, but it's operating without owner's consent. And they are both charged, and one of them did it and one of them didn't. And they both say that the other one did it. So one of them's lying and one of them's not. One of them did it, and they're pointing a finger and saying, no, the other guy did it. And the other one didn't do it and is saying, I didn't do this, that guy did it. The one who would be eligible for youthful offender status under DCF's plan is the one who was guilty. And the one who would have to go to criminal court under DCF's plan is the one who was innocent. And that just doesn't make sense. We shouldn't be rewarding people. We should be honestly, I think that whether you're guilty or innocent, if you have the qualities that mean you're going to be amenable to treatment in the juvenile court system, then that's where you belong, whether you're guilty or innocent. But when you make it depend on guilt or innocence and you say, we're only going to give benefits to those who are guilty and not give benefits to those who are innocent, you're creating a really just set of perverse incentives. You're encouraging people who are not guilty to plead guilty so they don't have to go through the criminal court system. And you're taking people who are guilty and saying, you get a benefit that you wouldn't get if you were innocent, which to me just doesn't make sense. And that's why back when that system existed, it was barely used. It was used sometimes as few as 11 times a year. At most, it was used 30-something times a year, out of about 1,000 cases a year. It was basically a non-existent status, and it was because it didn't make any sense. And so as lawyers, none of us advised our clients to take those deals, not often, because they didn't make sense. The system we have in place now, from our perspective, makes sense, but it does cause this problem we agree with. There is this ping pong problem where you can have too many transfer hearings. And we agree that that's a problem. We brought that up last year, and the legislature directed us to come up with a solution to that problem. And weirdly, and this is something I don't understand, but they directed us to come up with a solution to that problem by December of this year. I didn't understand that because I'm not used to the legislature telling me to do things 2 years in advance.
That was an accident, actually.
I'm used to them telling me to
It's
do
a-
things.
We meant this past
Right.
year, but.
I'm used to them telling me to do things 1 year in advance. So when I saw that bill, I immediately started working with Judge Zone to rewrite the first 3 sections of the Juvenile Proceedings Act to address the ping pong problem. And I've sent that, Judge Zone and I have gone back and forth on that. And we have a language to solve the ping pong problem in a way that I think is far more appropriate than this. And the reason why is, in order to be a youthful offender, first of all, it's a voluntary status. You cannot be forced to be a youthful offender. The reason for that is it's an adult criminal court status. You can be thrown in jail because you were a youthful offender. And when that's the end result, when you can be thrown in jail, that means that you're entitled to a jury trial, you're entitled to a public proceeding, all those things that go along with the criminal process, but not necessarily the juvenile process. So if you want to be a youthful offender, you got to waive all that. You got to say, I waive my right to a jury trial. I waive my right to a public proceeding. I understand that I'm giving up constitutional rights. And I am also waiving the right to essentially negotiate the outcome of my case if I fail. There's no plea bargaining in the youthful offender system. If you get hit with what we call the hammer, meaning that you get your youthful offender probation revoked, you go up to the adult court and you get sentenced like you just got found guilty by a jury. So it's a very, what we call, high stakes, high reward system, because there's a high reward, which is if you do this, and if you're able to be successful and not violate your probation, then you can get the benefit of having your record cleared and not having your proceeding be public. But if you screw up, it's like the worst case scenario. It's, as lawyers, we're 90-something% of our cases are resolved through plea bargaining. And what we're doing when we plea bargain is we are trying to limit our client's exposure to open sentencing. And that's what happens in youthful offender. If you screw up, there is no plea bargaining. There is just open sentencing. So if you're charged with something like, I don't know what, an ag assault, you're subject to 15 years in prison. There's no way around that. There is no way to limit that exposure. So our concern about what this proposal does is that it allows you to go straight from juvenile court to youthful offender and bypass criminal court. And the problem with that is there's a specific set of criteria for transferring up to the criminal court, and then a specific set of criteria for transferring down to youthful offender. And the way that this is written, that first set of criteria wouldn't apply, only the youthful offender criteria would apply. And that just puts things sort of backwards. It means that you're not actually applying all the criteria that you should. The proposal that has already been drafted, but apparently is not due till December of 2025, addresses that in a different way. It addresses that by saying the problem is that we already have too many different transfer hearings. And instead of creating more transfer hearings or anything, we're going to consolidate them all into one transfer hearing. And all of these transfer hearings have different criteria, and that's crazy. We're just going to collapse them into one. And so the proposal is for, if there's going to be a transfer, you hold one hearing. That transfer addresses all potential types of transfer to criminal court, transfer to youthful offender, and that encompasses every single criteria. So all the criteria for transfer from juvenile court to criminal court are included. It also requires judges to consider all the criteria for transfer from criminal court to youthful offender status. It just lumps it all into one hearing with one set of criteria and simplifies it and streamlines it. And that's what we think is the correct approach to dealing with these transfer hearings, because we agree they're a pain. They are not set up in a way that is efficient, and they're not set up in a way that's effective. But we don't think that this would be the solution to that.
In 1 second. So but my understanding of that proposal, it has all cases. There's not any distinction between whether it's big 14 or felony or misdemeanor. It starts everything in the family court and then has one ability to transfer. And am I mistaken? I think that's what we asked.
That's correct. That's what was the request, and that's what we drafted.
Right. And that's where I think that's definitely a proposal we want to look at, whether that's going to fly, whether we're going to be able to pass that, whether that's going to go into law. It has me, I think that's a stretch for people to have things start in family court. It's even the big 14. And that's why in the interim, because there's a good risk, good chance that that's not going to go someplace. I hope it does. I'm going to be pushing it. I think that it's the right thing to do. But why can't the family court, is there any reason that the family court can't do both? Maybe it's two separate motions, maybe it's two criteria, but why can't they do both the transfer to the criminal court, and then after they figure out that, we're going to send it to criminal court, they can do the motion for youthful offender, so they can have those combined? Why can't that happen now?
The main holdup there is that DCF wants to be able to write a youthful offender report before the youthful offender status hearing. That's you could get more information from DCF, but my impression from multiple years of this is they don't want to go into a youthful offender status hearing without the chance to write a youthful offender.
It's a risk assessment report, is that what it is?
It's a little more than that, yeah. They do a risk assessment and they put in some beyond that. Risk assessment's the core of it.
But wouldn't they have to do that still if we advance the plan that is coming out December 25?
Yes, but I think we had a way to write that in there. I'd forgotten how we did that, but we had a way to address that. So that was done ahead of the hearing, so that the hearing could just be one hearing with everything contained in it.
Okay, all right.
And I just will say this, as far as I'm not trying to yet pitch that idea, because we're certainly flexible about that idea, but I do think, I can't speak for anybody else, but at least speaking from the defense side, and I honestly think this is a pretty shared opinion, the idea of consolidating everything to one type of transfer hearing, I think will make everybody happy. Nobody, The problem that we all have is there's too many transfer hearings. We ping pong back and forth from juvenile court to criminal court to juvenile court again. And there's no reason to do that. And I think everybody's pretty well in agreement that that zigzag process doesn't make sense. Prosecutors don't like it, defense attorneys don't like it, judges don't like it. TCF doesn't like it. I don't know anybody who likes it. And I think everybody, whenever we talk about it, everybody says, yeah, there ought to be a way that we can just do this in one hearing.
So the transfers in that proposal, it doesn't depend on having everything start in the juvenile court, or does it?
Well, if it doesn't, then we wind up more with the system we have now. Because right now, if you remember from my presentation in here about juvenile jurisdiction, where I showed the chart sort of fading in color from one side to the other, we have a very granular system, which is good in a lot of ways, because what we're recognizing is there's differences between 14-year-olds and 16-year-olds. There's differences between 16-year-olds and 18-year-olds. There's differences between 18-year-olds and 20-year-olds. And so each one of those sort of granular categories has a different set of jurisdictional requirements. So one thing you could do, this is, the idea that I gather here in terms of what section 13 is trying to do, is to try to kind of expedite that transfer process. There's already a provision in, I have to look at my computer to tell you this. It's a provision in Title 33, 5204, sub B, sub 2, sub A, Romanet 1.
5204.
33 VSA 5204, sub B, sub 2, sub capital A, sub Romanet I. Romanet 1, I should get my, it's a Roman numeral, not a Roman letter. Romanet 1.
All right.
That section was added just a couple of years ago. And what that does is it provides a specific list of offenses that anyone who's over the age of 16, regardless of whether the prosecution wants it, regardless of whether anybody files a motion, there's an automatic expedited transfer hearing. To the extent that the concern was that you were looking to add case types to that list, you could add case types to that list, which is in 5204. And that, because we already have a provision on expedited transfer hearings.
Right.
And it doesn't make sense to build another section on expedited transfer hearings when we've already got one. So to the extent that there is something to fiddle with, that's where I would suggest going, because that's already our expedited transfer hearing section.
Right. Okay. All right. Appreciate that. Ken, go ahead.
So about 15 or 20 minutes ago, when I first had my question, when I was just a ping pong ball, and now I've gone to a volleyball and getting the crap kicked out of me. If I can remember backing up to this point, you said the ones that aren't guilty are still being charged or something like that. I think, just let me go, because I'm trying to remember everything. I think what you were saying was the ones that really aren't guilty, they're taking the blame or something for the ones that is taking the blame. Was that what you were saying?
Not necessarily taking the blame, but they are subject to criminal court trial. So that if you're not guilty, you can't plead guilty because that would be lying under oath. So you have to insist on your innocence, which under TCF's proposal would mean you remain in criminal court and you're tried publicly and either found guilty or not guilty and subject to criminal sentencing and all of that. If you are guilty and you plead guilty under DCF's plan, then you get all the benefits of youthful offender. And to me, that's why the old system was almost never used and why it was so unfair, is because it really benefited people who were guilty, and it rewarded people who were guilty while punishing people who were innocent, which to me is just simply kind of a perversion of the purpose of the justice system.
Okay, help me. The people that are guilty, they admit they're guilty. That's a no-brainer.
Let me give you an example, and I'll just use myself. So let's say I'm an 18-year-old kid, and I steal a car, since that's what I've been using as an example, and I'm caught and I'm guilty, I can go in and I can say, I'd like youthful offender status. I'm charged in the criminal court as an adult. I go in and I say, I'd like to get youthful offender status. And the court then transfers it down and decides whether or not I am amenable to treatment as a young person or whether I belong in the criminal court system.
But you sold a car and you're making this deal.
This is our current system. The
Gotcha.
current system, I can go in and say, you know what, I'm a young person and I would benefit, instead of being treated by DOC, I'd benefit by being treated by DCF because I'm a young person. And so I want youthful offender status.
Okay, gotcha.
That's the current system.
Yeah.
If I was not guilty of stealing a car, if I was accused of stealing a car, but I didn't do it,
Yeah.
I could still do that under our current system. I could say, you know what?
But why would you do that if you're not guilty?
Because being charged with stuff is all it takes. A lot of my clients who are found not guilty in criminal court, who have their charges dismissed, they still lose their jobs. They still lose social standing. They get fired from jobs. They have people who were their friends who won't be friends with them anymore. Being arrested and being charged in criminal court, I mean, in my county, or in the county I used to live in Lamoille County, every arraignment is listed in the News and Citizen every week. They don't say when somebody's been found not guilty or the charge has been dismissed. They just list the arraignment. So there's a real penalty to being charged. Being charged does not come with that penalty.
But it's still a public record that the case was, you're not guilty, the case was dismissed.
But nobody finds that and it's not published anywhere. If you Google yourself, you won't find a record that says case dismissed. You'll find a record that says person was charged. That's because Google doesn't search our Vermont judiciary system. It doesn't show, when you search Google, you're not going to get a PDF from Odyssey. What you're going to get is what the News and Citizen reported or whatever the local paper reported. And the local paper reports on arraignments. They don't report on dismissals.
I'm thinking. Yeah, I'm just gonna let that for now.
Other questions or do you continue on if or does that cover what you?
The other thing I would say is we support section 14, the same reasons that we support the sections that delay the implementation of raise the age, because section 14 is integral to that.
And we're probably going to add in a reporting requirement, much like what we were having them report on, so we can keep track of the progress. And
Yep.
We'll have a chance to weigh in on that if you wish.
What are you talking about? Reporting on the progress, the five issues that.
No, so DCF was providing every other month a report to Joint Justice Oversight and then to all the committees. And I don't know if you were here at the time, but I noted that those were actually very helpful to kind of track what was going on. And I think that we should continue that, but not every other month, maybe like 3 between now and July of 27, just so we can follow progress. And so, yeah.
Can I add one comment that's more directed just sort of globally, not necessarily at this bill? And
Yeah, no,
but it was a subject of conversation that came up today, which is the notion that keeps being repeated that people who are over the age of 18 have no consequences when they violate probation. There's a grain of truth to that. There's a grain of falsity to that. And there's also just a big picture thing that everybody should be aware of that doesn't get talked about when we talk about that. So here's the thing is, in Vermont, we have historically done something that other states haven't done. We've had a unified child welfare and juvenile justice system. And that means that we've used one set of statutes to address both child welfare issues and juvenile justice issues. And that comes into play in an important place, which is when it comes to what does state custody mean. So when we take a youth into custody, DCF will talk about the fact that they can't take people into custody over the age of 18. That's true because of the weird way that we've structured our system. To my knowledge, every other state in the nation except for one, and I've forgotten which state that is, but I looked it up and there was only one other one, does not do this at all. Every other state in the nation treats custody differently for purposes of child welfare versus juvenile delinquency. So when somebody comes into custody for child welfare purposes, the state is their parent. The state takes over the parental role. The state can make decisions about medical care. The state can make decisions about education. The state can make decisions even about religious practices. The things that we as parents get to decide about our children, the state gets to decide when they take a child into custody. That's normal in the child welfare world. All 50 states, that's how it works when somebody is taken into custody because they were abused or neglected. To my knowledge, in 0 other states does that take place when you come into custody as a delinquent. And in most states, when you come into custody as a delinquent, you come into physical custody. They don't take custody over all of the legal aspects of your existence. And so in other states, let's say that a young person, a 14-year-old, a 15-year-old, a 16-year-old, does something that gets them taken into custody, put into a juvenile facility for a while. The state may have physical custody of the child, but the parents still have the rights to make all of the medical decisions, all of the decisions about education, religion, any of that. We are bizarrely an outlier in that regard, and that leads directly to the problem that DCF was talking about, where they say we don't have the ability to impose punishments on people who are over 18 who violate probation. And that's because we've stopped DCF custody at age 18 because it doesn't make sense to give custody of an adult, legal custody of an adult, to the state. So when DOC takes custody of someone, they take physical custody, but not legal custody. They're not making that person's medical decisions for them, that kind of thing. All we would have to do is join the 49 other states that say that when DCF takes custody, they take physical custody only, and then DCF could take custody all the way up to the end of jurisdiction, which is what happens in every other state. So in every other state, if you are, let's say, other states, you can't come in as an 18-year-old. So let's say you're a 17-year-old, but you can be supervised to age 22 in a lot of states, 23, 24, 25 if you go to Washington State. And so as a 17-year-old, you could be taken into the juvenile court system. You could be, if your needs were severe enough, brought into a secure residential facility, like essentially a juvenile detention facility, or something lesser than that, maybe something more specialized. And they can hold you there until you turn 20, 21, 22, 23, whatever their cutoff is. Vermont, we are the ones that weirdly say, everything after 18 is voluntary. If somebody says they don't want to be in custody, then they don't have to be in custody. That's a really weird thing. That's not something that the 49 other states do. That's a unique Vermont thing. I don't know that I think there's probably some positive aspects to it, but there's definitely some negative aspects to it too. And those are the things that we're talking about here, where we do run into the small, as has been acknowledged, it's a tiny percentage of people who are resistant to probation treatment and who sort of fight against that and leave us in a spot where we don't have a remedy for that. We could remedy that just by being like the other 50 states and saying, you know what, if you violate your probation, even if you're over the age of 18, if you're still under the supervision of DCF, you might be pulled in. You might be taken into a facility, or whatever else. There's a full range, but that's the sort of top end punishment. And that's something that I don't know why we have it set up the way we have it set up. But that's what leads to that problem that's been brought up a few times. That again, I think is important to address, that it's only a tiny proportion of the 18-year-olds that cause this problem. But I agree it is a problem, and it's something that we could fix simply by kind of joining the rest of the country. And
so how that part sounds simple, but what's the language that gets us there that we can
I
think?
don't know the answer to that off the top of my head. If you told me to come up with it, I'd come up with it.
I think I might have Eric reach out to you, to try to figure that out, because I mean, that could address the accountability issue that we keep on hearing, that gap. And you identified what that gap is. Yeah, well, we've heard about that gap as far as not being able to take custody in the sense of our family courts and DCF of somebody who's 18 and 19. So,
And like I say, it just, to me, that the problem with that argument isn't that it's not true. It is true under our law.
right.
The problem with the argument is that 49 other states do it differently, and I don't see a reason why we couldn't do it the way they do it.
The only issue currently is that if there's custody where we're detaining the person, we don't really have some place that we can detain an 18 or 19, well, 18-year-old as a child who is being treated as a in the juvenile delinquency.
You know, that from our perspective, that is what needs to be further developed. We want to see that capacity. When Red Clover was initially opened, we were expecting that it would be caring for 18-year-olds. We were surprised to find out that it didn't. That's not a disparagement of their program. They have an excellent program. Like I've said, I'd love to see it expand to include 18-year-olds. It wouldn't, from my perspective, that's not a stretch. If you're caring for there's no difference between 17-year-olds and 18-year-olds as the parent of a 17-year-old and a 20-year-old. Like,
Right.
it's, they're not making decisions in a different way. They're not really more mature than each other. Probably shouldn't have said that on the record. But really, I mean, what we would like to see is we would just like to see this system work. And that means some things that might seem kind of counterintuitive. We want to see a good quality, secure juvenile facility built in Vermont to care for our highest need, highest risk kids. We think that's important. We don't think we can have a safe system without that. DCF sort of talks about the issues where they have to staff youth in a hotel or something as a reason why there's problems with our Raise the Age program. We agree, but our proposal is don't scrap Raise the Age, fix the problem. Other states aren't doing that. Other states have found ways to treat their youth without having to do that. And we hate that too. That's dangerous for DCF workers. We understand that. It's also dangerous for the youth. Like, the youth are being staffed. We're usually talking about youth who are in crisis. They're being staffed in a non-therapeutic environment. It usually escalates the crisis, doesn't de-escalate it, because it's not the right environment for de-escalating a crisis. The staffings that have happened in the last couple of years have been a lot better than the ones that were happening before that. I think they're using more highly skilled staff, but there was a time when there was people being used in these staffings that just were not skilled enough to be doing the staffing in a safe way. It wasn't safe for the worker, it wasn't safe for the youth, and it wasn't the right environment to accomplish anything productive or positive. Again, we agree with a lot of the problems that are brought up. We just don't see those problems as reasons to scrap the system. These are all problems that are easy to fix. In fact, most of these problems have been fixed by like the vast majority of other states already, and all we got to do is follow their lead.
So, yeah, that's something to look into, and maybe we'll have a delayed date until we actually have a place, the higher end, as we've been talking about, which we don't really have right now, other than Red Clover. But
Well, again, what I would suggest, we think that delaying 2 years is the right thing to do. When we originally were looking at this, we were internally, we wanted to do a 1-year delay. We thought that was appropriate. We've since, in looking at it and talking to some of our colleagues at some of the facilities, we've said, I think 2 years is actually more realistic and more appropriate. I don't think further than that is necessary, because really everything that we're talking about could be put into place pretty quickly. There's nothing that couldn't be put into place promptly. There are things that, granted, we're all excited for this, for the facility in Virgins, which is, if all goes as planned, will be beautiful and effective. It's going to take a long time. I mean, they're talking about years before they put shovels in the ground. And we don't need to wait.
250?
No,
No, it's state land, so it's just the nature of, you have to talk to BGS. That's simply what we've been told. I'm not a construction expert. They've been told.
250?
I don't believe so because it's on the grounds of the old week school.
I've never heard that that's actually the holdup.
Right, not a holdup, but it could be.
No, I think it's just an issue of, I mean, literally there's a lot involved. It's architects, it's, there's so many people involved in this. Most of the time when I sit in on a meeting, I know everybody on the screen because we have the same meetings with the same group of people who are addressing the same issues in juvenile and criminal justice. And when I join the Virgin's facility meetings, it's full of people I do not know. People from the construction company, people from the architecture firm, people from BGS. There's a real lot that goes into building a new building that takes time and it's beyond my expertise.
And there's local zoning and negotiations between Virgins and BGS that seems to have delayed things. Yeah, so. All right, any other questions for Marshall at this point? So go ahead, Tom.
Yeah, it really doesn't. Along the lines of permits and all that. I didn't know if there's federal money involved.
Yeah, I can talk about the federal money. I think,
The reason I'm going,
yeah,
some experience that I have with it is that years ago when I had my tree company, we were, before there was a Doppler at Rutland Airport, they were going to put in the Doppler and the state stepped in and said, you can't do it because of Act 250. And Jeffords came up and said, put it in. And 2 weeks later, we were in there cutting the trees.
oh, gotcha.
So I'm just wondering if there's federal money involved, if the feds could do some of the same work. So
I didn't understand your
That's what's going
question fully. So the short answer is, I have no idea what federal funds are available for the construction of facilities like the state is planning in Virgins. I wouldn't be optimistic that there's a lot out there, and I say that mainly because that money would probably flow through the Office of Juvenile Justice and Delinquency Prevention, and they've been really focused on directing their funding to non-secure facilities, trying to get states to move youth out of locked facilities and into therapeutic facilities. So if you can look at some DCF charts regarding funding, and you can see there's a plummet in there where OJGDP changed their funding formula and wouldn't fund secure placements and I think even staff secure placements at the same level that they would fund community placements. So I don't think, my guess would be that we shouldn't be optimistic that there's federal funds coming for that. But Attorney Bernstein, the child and youth advocate, did talk about the potential of, he had estimated $1.75 million in federal 4E funds that we're currently not drawing down, but could be. And I would agree with him, and I actually think that's an underestimation. Our office thinks it's probably closer to $4 or $5 million in 4E funds that we're not drawing down. There's still some complicated steps in terms of what it takes to get that, and some of it may involve that we're not eligible to draw those funds down until DCF's computer system is upgraded to the point that it can provide reports to the federal government about that 4E money. So there's some complications there, but there is a huge pot of federal money that 30-something states are pulling from, and we're one of the minority of states that's not pulling from. And it could be quite a pool of money, and it would be all around juvenile justice and child welfare. Those 4E funds are they're very generous and they are, one of the things that's great about them, especially in light of the current situation around federal grants and federal funding, it's not actually a grant, it's an entitlement. It's a state match. If we spend the dollars, which we're already spending, then the feds match them. And right now, we just don't have the systems in place to draw that down, but we're already spending the money. We're just not getting the federal matching funds that we could be getting.
All right, thank you, Marshall. It gives us a lot more to think about. We'll have another version of this, early next week, and hopefully this is the penultimate version we have in front of us right now. Really appreciate it. Well, that's all for today. We're picking this up again tomorrow with a number of witnesses